Welcome, Mr. Ethasham sir. Yeah, very good morning to you. Yeah, I understand, Ethasham sir. It's all right. Yeah, very good morning, Jamshed bhai.
Good morning, sir.
Good morning. How are you?
I'm fine, sir. Sir, and you? What about you, sir? Are you
Yeah,
good?
I'm fine, brother. I'm fine.
It's long time that we could not see you here, so I hope that we will see you soon,
Inshallah.
inshallah.
Welcome, Miss Anupa, and very warm good morning to you.
Good morning, sir. How are you?
I'm fine, ma'am. What about you?
I'm also fine, sir. Thank you.
Yeah, you're welcome. Well, today I propose another important engagement that is also a continuation of our understanding of the definition, paradigms of definitions, grounds of persecution, while keeping in view whatever we have deliberated in the previous engagement. This new engagement will also shed light how refugees are generally protected globally, regionally, and locally. This is an engagement on the institution of asylum, non-refoulement, and we are going to explore the possibility, feasibility for the expansionization of existing grounds of asylum beyond our traditional understanding regarding granting of asylum, which is popularly known as durable solutions. So we have to look beyond this traditional understanding of durable solutions. And particularly, we have to assess to what extent we would be able to contemplate and envision any kind of an idea beyond current contours of international refugee protection regime. As I have already submitted on many occasions during reference points, and as an inferential consequence of our engagement ever since we have started dabbling in the area of international refugee law, that institution of asylum is the most controversial, polemical, and contested and converted institution in the field of international human rights law under international law, as well as other important independent branches of international law. There has always been some contrast between immigration law and refugee law. And one of the most important controversial topics that remains there, that is institution of asylum, because the institution of asylum not only takes into account the sovereign concerns but it has become a bone of contention among the nation states. The institution of asylum has been casting a cascading impact upon international relations, foreign policy paradigms, sovereignty, sacramentality, and other important incidental and connected aspects of international transactions. Therefore, we have to understand, my dear friends, what exactly are the new dynamics of international refugee law and how these dynamics and semantics have been changing, who are the scholars who are basically keeping a tab on these dynamic developments in the field of international refugee law. Particularly, we have to take into account the scholarships provided by Alexander Betts from Oxford University, Professor Gaius Goodwin, again one of the most important colleges affiliated to Oxford University, that is the All Souls College. We have to undertake what has been their contributions in understanding, and again what kind of a new aspect that has been brought to light by Alexander Betts, particularly the survival migrants concept that has to be understood in the light of new dimensions in the field of asylum law. And we have to understand how the national legislations and national laws are different from what has been incorporated and presented for our consideration under 1951 UN Convention relating to the status of refugees with its additional protocol of 1967. Apart from this, we have to understand the concept of asylum in a historical retrospect. What could be the possible definition of asylum and what kind of an attempts have been made in defining this particular institution, that is the institution of asylum. We have to further understand what are the practices, patterns of asylum in global south nation states, and how these practices and patterns are different from the global north patterns and practices of granting asylum. Particularly, there are certain important vulnerable sections who are also seeking asylum in another country in the light of Universal Declaration of Human Rights. Particularly, I am talking of LGBTQI applicants, and to what extent they have been successful as a social group, as by virtue of being a member or due to their membership of a particular social group, that we have to understand. At the same time, we have to understand the asylum policies of major international players in the field of asylum law or in the field of granting of asylum at national level. Particularly, we would be deliberating certain important cases which have been decided by the Ninth Circuit Court in United States of America. Some of the important jurisdictions like UK, Australia, South Africa, as well as what has been the judicial response with regard to asylum by the judicial establishment in South Asian jurisdictions. So we would also be, having an understanding on these aspects in our part of the world. At the same time, we have to further, explore the possibility how to expand the existing grounds of asylum that has to be taken into consideration. And we have to understand, my dear friends, what may be the possible grounds from global north point of view as well as from the global south point of view, that we have to understand when we are talking of the institution of asylum. Before I take you further, we should try to understand what other important dimensions, particularly the family unity, family reunification, preemptive norms of international law, domestic courts response, at the same time, how to defend refugee rights, and how to expand the grounds of asylum, what has been the role of non-governmental organizations, how international non-governmental organizations have been functioning in the area of international refugee law. And for that, we are supposed to have another important series of some of the most important understandings. Particularly, that understanding has to be gathered from legal instruments which we have to understand. Particularly, if you take into account the 1946 Constitution of International Refugee Organization, then we have to understand 1948 Universal Declaration of Human Rights. Then we have to undertake 1949 Refugees and Stateless Persons. That is another important resolution. Then we have to understand 1950 Statute of the Office of the United Nations High Commissioner for Refugees. Then again, we are going to understand the 1951 UN Convention relating to the status of refugees, what exactly has been there with regard to asylum. Then we have to understand 1957 agreement relating to the refugee seamen. Then again, we have to understand 1967 additional protocol to 1951 UN Convention relating to the status of refugees. Then we have to undertake another important what we call dimension that is provided in 1973 protocol relating to the refugee seamen. Again, we have to understand 1984 UN Convention on torture or against torture. Then we have to undertake 1985 Convention concerning international cooperation regarding administrative assistance to refugees. Then again, UNHCR agenda for protection of 2003 that we have to understand. Again, UNHCR handbook, particularly on voluntary repatriation, that provides international protection. And at the same time, I would also be sharing these instruments with all of you. And another important dimension would be, and that is the requisite readings that I would definitely be sharing. So before I proceed further, let me give you a very important dimension, and that is regarding what you call asylum. If you take into account, and thereafter I would be evaluating some of the important questions in this particular background. So far, institution of asylum, the controversies, the world asylum crisis, and what exactly we are going to witness in 2021. Because we are in the beginning of the third month of 2021. The whole year is ahead of us. So what exactly is there in store? So we have to understand, in our part of the world, that is South Asia, we understand what exactly are the asylum policies, refugee policies, and how, what kind of an atmosphere is there for the reception of refugees in South Asia, in Southeast Asia, or beyond South Asia, in our vicinity, so, or in the vicinity of South Asia, that we have to understand. But beyond this, there are certain important developments which are taking place, and we as South Asians are not worried enough regarding those particular developments. In the past decade, my dear friends, if you take into account the last 10 years, 1 decade, the global refugee population has more than doubled. And what we have been witnessing, let me give you some of the important accounts collected from different what we call countries. Particularly if you take into account one of the most important country in terms of the refugee influx, in terms of the refugee crisis, and that is Burundi. Over 3 lakh, more than more than 3 lakh 80,000 Burundians living as refugees, for being the 10th largest refugee crisis which they have contributed to. And at the same time, the Burundians as refugees are not getting any kind of an international solace in the form of finance, in the form of some kind of a financial funding. Almost all Burundians, my dear friends, or Burundian refugees live in neighboring countries like Tanzania, where we find more than 2 lakh refugees of Burundian origin. Then Rwanda, that is also hosting around 70,000 refugees. Then the Democratic Republic of Congo, where we find almost more than 40,000 refugees are presently being hosted. Then Uganda is also there. Then the Kenya, Zambia. But if you take into account this entire canvas of refugee crisis in the 2021, then this kind of a situation creates a knock-on effect of strained resources within the host communities. Despite the fact we have already adopted the global compacts, but it has created a lot of what we call insecurity, lot of weight on the existing resources, and it has also exposed the vulnerability of the host countries, where they are tottering. Particularly their logistical infrastructural support is tottering under the weight of refugee exoduses. So you can very well understand what kind of a crisis is there. And therefore in this particular circumstance, we have to understand what exactly has been the response of international community of nation states. This has generated certain specific questions with regard to asylum. And the question sometimes, prima facie speaking, appears to be very, very novel, innocuous, and very simple. Suppose, what are the new emerging dynamics of international refugee law? And how to, identify them? Though it appears easy, but it is very difficult. Again, there is another important, ancillary question to this particular, question. What are the basic protective principles that are under strain if we take into account or if we measure the current refugee crisis? Why courts, civil society, and refugee reasserts the right to protection? What are the new windowsills of the role of international and domestic courts in refugee protection? Another important dimensions that should also be visited, and that is relating to how to problematize the practices of asylum in some global and global south nation states that are sometimes of dubious what we call legality, which undermine refugee protection in multiple manners. What are the various strands that really lead to measures to preclude access to asylum the measures to undermine the reliability of the refugee status or determination mechanism, the measures to seek to clarify the obligations to refugee beyond 1951 UN Convention relating to the status of refugees. What role has history played in the current conceptualization of refugee protection? And that generates another important ancillary question, my dear friends. Can history enhance or hinder a progressive approach, a pragmatic approach, a plausible approach? What does protection currently mean? Because protection has to be understood in its entirety, and I would also be coming to that particular aspect, how to understand and how to appreciate the contours of protection. But is it right based or assistance based protection? What kind of a protection, my dear friends, we have been talking? Or in other words, let me put it like this: does protection means something different for different groups at different stages of flight and in different spaces? How should such issues be addressed while taking into consideration the current visage of the refugee crisis, and what kind of a burden is there on the institution of asylum? What are the moral and practical approaches to protracted refugee situations? What roles should be played by protection, integration, or citizenship in this particular contextualization? Is it time to drop the term refugee if we are contending? Because there is a scholarship who is not comfortable with the current what we call vision of this particular word that is known as refugee. So should we discard the current what we call connotation, current understanding of the term refugee? Has the time come? Because most people seeking safety, not refugee status. So in such a situation, those who are there are group of people, individuals are there, groups are there who are seeking some kind of a refugee status, some kind of asylum. Because asylum is different and refugee status is different. We would also be coming to that particular aspect. But at the same time, there is a emerging scholarship who is contending, let us what we call contemplate a better word, all comprehensive word, which incorporates not only, which encapsulates not only the term refugee, but other important what we call dimensions or emerging dimensions of movement, forced movement, or the forced displacement. So how to understand this particular controversy, or this particular multiplicity of dimensions? Would the adoption of a different term in the same way, let me put it like this, would the adoption of a different term such as forced migrant, survival migrant, as Alexander Bates of Oxford University is talking of currently, or fleer of necessity? Another important scholar, I am talking of Alan Koff, who is arguing in favor of, instead of confining our understanding of refugee or to refugee, let us have another important term, fleer of necessity within inverted commas. Mr. Alan Koff, along with what he call Zamor, another important scholar of international refugee law, they are coming with these kinds of understandings. Then we have to understand all these dimensions, and at the same time try to appreciate what are the implications, what would be the implications for protecting such classes of people. So because we cannot discard or underestimate the political dimensions, because it is the politics that determine the legal issues under international law. That is my simple understanding. Because what may be a political question, it may be a legal question for other countries. If country A considers a question as legal, there is every possibility the same question would be construed as political in another country. So there is a question: do foreign policy considerations of nation states still affect refugee policy and practice or refugee protection? What are the politics that support the issue of refugee and asylum policy? We have to understand this. How are asylum cases determined in different parts of the world? Whether it is the United States of America, European Union, or African Union, or other important major jurisdictions, national jurisdictions, how these considerations cumulatively are being addressed, because what we have been witnessing, particularly the after the decision in Sale versus Haitian Centers Council, what we have been witnessing, that there is a trend where we find increasing restrictionism in immigration, and that ultimately breeds some kind of a abuse of the institution of asylum. False documents and trafficking rings have also been what you call produced out of this particular institution, that is the institution of asylum. At the same time, what exactly are the different groups who have been seeking asylum, or their asylum rights happens to be in constraint? So we have to understand this entirety, because the children, LGBTQI stakeholders, women what you call stakeholders, they are the vulnerable groups, and therefore very marginalized what you call groups. Therefore we have to understand entire what you call canvas of the institution of asylum. When we are talking of asylum, then there is a question, and that is relating to rights of refugees. Whenever we witness some kind of a newspaper at international level or national level, then I have collected certain important headlines from the different what you call newspapers, and these headlines constitute a very important understanding, and these understandings under all circumstances be understood. If you take into account, suppose in various newspapers we generally come across stop the asylum invasion, new shambles over asylum, poison gang are asylum seekers, asylums blamed for AIDS crisis, asylum threat to house prices, non-international armed conflict and civil strifes is the cause of skyrocketing prices. Asylum seekers are radicalizing the host societies. These kinds of, my dear friends, these kinds of news items which I have collected, particularly from the British newspapers in the last 20 years. These are the front page headlines which appeared in the British newspapers from 2000 to 2020. So there has been a pattern how they have been writing, and what kind of a role is there of of media, and how the media has been depicting refugees, asylum seekers, migrants, and the people who are fleeing persecution. It is also axiomatic from these headlines that even in 2020, in that year, it has also witnessed an extraordinary effort on the part of the press, supported by certain pressure groups and politicians, to convince the British public that the majority of asylum seekers are cheats, criminals, and charlatans. Even some commentators have also suggested, and I understand their naivety, that the current challenge to asylum is simply a result of the competition for newspaper sales, and it has no deeper social or political significance. Everything has become the part of what you call of incremental nature of readership of a particular newspaper. But the biggest casualty in this particular crisis that still remains to be addressed, and that is the idea of protection. How to conceptualize the idea of protection that still remains shrouded in some kind of a obscurity, and how to take this particular idea in the daylight, that is going to be the best what you call service for the cause of refugee protection or for refugee welfare. Because if you take into account this particular word protection, then it appears the protection is a very nice word, a noble word, a gospel word, an ecclesiastical word. The concept of protection, my dear friends, is a very primitive and ancient one. It has been, the word protection has been cited liberally in Hebrew scriptures, if we study. It has also been, again in a very liberal fashion, it has been cited in the New Testament. It is also there in Quranic injunctions. Even in Rig Veda, extensively, if you take into account the entire religious scriptures of Hinduism, then very prominently and liberally it has been used in Rig Veda. And other important, divinities and other religious, writings, we come across that the word protection is there. The word protect or protection comes from the Latin terminology, which is known as protectigere. And the meaning of this, word protectigere is a shield, a kind of a shield, a kind of a cover, a kind of a, protect, a kind of a, defense or to defend. Therefore, over the ages in Western civilization, the term has been used in various ways. For example, God's protection, royal protection, diplomatic protection, self protection, legal protection, or protection under the law. These are the different what we call, and more recently, if you take into account what kind of a, jurisprudential aspects as well as the other important recent aspects which have been attributed to protection, and after these attributions, it is known as, particularly in democratic political setup or other important what we call setups of governance, the word protection has also been used in the form of equal protection, trade protection, consumer protection, social protection, environmental protection, copyright protection, and so on and so forth. Therefore, the word protection is used, my dear friends, by historians, political scientists, anthropologists, lawyers, politicians, and even theologians with somewhat different meanings. The word protection always presented a very, very positive connotation. Suppose protection means to defend, to guard from danger or injury, to support or assist against hostile or inimical, unfriendly action, to preserve from attack, persecution, harassment, etc., to keep safe, take care of, to extend patronage, to shield from attack or damage, and to provide assistance and other important, notions of protection. Then there is another important understanding which I must share with all of you. That is, what is the difference between refugees and migrants? The most important discernible difference, my dear friends, between refugees and migrants. In case of, refugees, a refugee or refugees do not choose to leave. Or in other words, let me quote Sir Sadruddin Aga Khan, within inverted commas, nobody wants to be a refugee. That is the most fundamental understanding. So, my dear friends, refugees do not choose to leave their country of origin, the country of their nationality, the place which is known as their homeland. They generally don't choose. In the context of migrant or migrants, migrants still have protection of their home countries, but decide to leave of their own volition. They take a decision about leaving their country of origin, but this is not possible in case of refugees. They are compelled, they are forced to leave their country of origin. As per 1951 convention, my dear friends, in case of refugees, there is a fear of persecution. There is a fear of persecution owing to the fear of, or well-founded fear of being persecuted due to certain important, reasons, and these reasons have been adumbrated. But in case of, migrants, what we find is why migrants can still return without fear of persecution to their country of origin, because they voluntarily, on the basis of their will and volition, they have left their country of, origin for economic reasons, for better what we call, reasons, and just to earn a better livelihood, just to eke out a dignified existence in the financial or fiscal, trajectory in other, nation states. In case of, refugees, they also flee generalized, violence. But with regard to the, migrants, people fleeing natural disasters are not refugees, and that is the bone of contention, and that is what we have been witnessing. A kind of a new discourse is emerging on climate refugees, environmental refugees, whatever may be the, nomenclature. But because of the, climate change, because of the natural, disasters, because of the natural calamities, people are, displaced, and climate change induced displacement and migration has become a new kind of, discourse, and it is under, debate. And that is why we have been, talking of, a new idea of, durable solutions, and new important, streams of understandings in this particular, discourse is also, emerging so far. Natural disasters and the people who got, displaced because of, natural disasters. So we are witnessing a new kind of a, discourse. We would also be taking up that particular, discourse at a subsequent, stage. Then in case of, refugees, there is a serious what we call, violations of human rights. So because of the serious violations of human rights, because of the generalized violence of, human rights, because of the massive violations of human rights, people are getting displaced. And that is why such, events, when these events have been, causing serious disturbances of law and order, people, flee. Suppose because of the, communal rights, because of the racial, rights, because of the caste rights, because of the, linguistic rights, because of the, jingoistic what we call, rights, people are, displaced, and they move from one place to another place, and sometimes they have been crossing international borders. But there is another important right, and that is right to development. When right to development, we generally talk of because of the accessibility to right to development, it has also created other forms of violations of rights, because right to development in the particularly when the governments and the communities, they have been collectively seeking right to development, or individually this particular right is being accessed, that right to development in terms of what we call of modern day concept of development, what we have been witnessing, that is the construction of big dams, deforestation, industrialization. Sometimes it is reckless, lopsided. Then other forms of developments are also taking place. That has also what we call presented a new kind of a situation, particularly in terms of development induced displacement. So that has to be taken into consideration. But one of the most important questions that still remains to be answered, and that is, what is international protection to refugees? So when we are talking of what is international protection to refugees, and how to restore, and how to what we call grant asylum, because there is a law in the form of Universal Declaration of Human Rights and the two important covenants of 1966. Then we are also having number of other important instruments. At the very beginning, I have presented entire list of what we call of legal instruments. Then in such a situation, what is international protection? That is the most important question. When we are talking of international refugee protection, it has also evolved as a surrogate protection to national what we call protection, when we are talking of the international protection to refugees. So the surrogate protection idea is also there. It has been presented to the idea of national protection, because it results from the failure of the state to protect human rights. That is why the idea of international protection has been envisioned. Otherwise, it is the responsibility, when we are talking of international protection, then it is the sole responsibility, my dear friends, of the national governments to extend protection to their what we call citizens. But there are citizens who are alleging that there is a process, there is some kind of a hate, there is some kind of a displacement, there is a massive violations of human rights, there is a religious persecution, caste persecution, racial persecution, and they do not have any kind of an option except to leave their country of origin, because they are having a fear of de-citizenization, they are having a fear denationalization. So these kinds of fears, or deterritorialization, these kinds of fears presently we find in the new kind of discourse when we are talking of the refugee protection regime, and what exactly are the challenges before this refugee protection regime. Then if there is a question of of international protection, and what is international protection? International protection, as I have a moment ago submitted, it's a kind of a surrogate protection to national protection. And why, under what circumstances international protection is generally sought? The international protection is generally sought in the absence of what we call the national protection. When there is an absence of the national protection, international protection is generally resorted to, because a state offers its citizens a number of rights and privileges that only states can provide. Suppose access to that state's judicial courts in case of any kind of a violations of somebody's human rights, or the violations of an individual's or a community's or a group of individuals human rights. Then the rights or right of citizens to vote in national elections, this is again which is also granted by the state under its constitution. Then access to its social services structures, the healthcare law and other enjoyment and accessibility to other important rights which have been granted under the national constitutions. So it is the responsibility, my dear friends, of the state to grant all such kind of a right, because where a nation fails to protect its own citizens rights and privileges, then another nation, either as a matter of charity or international obligation, may assume the responsibility for the protection of those very citizens. That is why it is a surrogate protection to the national protection, because it has been provided because of the special circumstances. What are those special circumstances? Special circumstances are the massive violations of human rights, the generalized violence of the crisis of proportion, ethnic cleansing as per the 1948 Genocide Convention, or other forms of violations, and the violations which have been prohibited under the core 9 international human rights treaty instruments, along with the 4 Geneva Conventions, a Rome Statute under international criminal law, and of course we should not forget 1951 convention, UN convention relating to the status of refugees. So these are some of the important instruments which have generated and warranted special what we call treatment and special circumstances. Suppose take the example, for example, we can talk of human trafficking. So individuals left their country voluntarily or were coerced into some kind of living or abandoning their country. It is generally what we call seen and witnessed in human trafficking cases. Individuals may be in need of international protection in some kind of in these kinds of situations after arriving in another country. Then human trafficking syndicates may also entice people by presenting some kind of a utopian picture of the foreign lands. They may also present them some kind of a dream in terms of a poverty free life, a hunger free life, a starvation free life. That is why in such situations of human trafficking, people require international protection. Because if you take into account the concept of international protection, particularly how it has been made available to refugees, then a refugee benefits from international protection when national protection, my dear friend, is not provided to him or her, because national authorities are not capable or not willing to provide the necessary safeguarding of rights, and he or she has crossed an international border. Then the idea of international protection comes into picture. The law of asylum comes into picture, because international protection is meant to be a temporary safeguard of refugees' rights until what? Until some kind of a limitation. What kind of a limitation? The protection of the government of the country of origin or the nationality can be resumed at a subsequent stage. And that is why the idea of voluntary repatriation as one of the most important part of the durable solution has been contemplated. Then there is another important situation. The situation has changed so that the surrogate protections or protectors role is no longer needed. Then that is another important what we call dimension. Then in such a situation, there is another important what we call question: what exactly are the objectives of international protection? Yes, international protection is provided, refugees are getting some kind of a benefit, but at the same time it is equally important to understand what exactly are the objectives of international protection. International protection of refugees, my dear friends, begins with securing their admission to a country of asylum. That is the very first step which is generally resorted to. Then international protection proceeds through the grant of asylum and respect for their fundamental human rights, including right not to be forcibly returned. Forcible return should not be there. That is the most important aspects. If you take into account Article 13 and Article 14 of the Universal Declaration of Human Rights, you will find a categorical understanding that the right to leave and right to return is an exclusive right which is exercised by an individual, and it is free from any kind of a coercion, any kind of a duress. So therefore, right not to be forcibly returned is also incorporated, it is impregnated in this particular article of the Universal Declaration of Human Rights, which is known as Article 13. Then when we are talking of right not to be forcibly written, we are primarily talking of, my dear friends, the soul of 1951 UN Convention relating to the status of refugees, and that has been incorporated under Article 33 subclause 1 of this Refugee Convention, which is popularly known as Non-Refoulement, or the doctrine of Non-Refoulement, or the institution of Non-Refoulement. Because it ends only with the attainment of a durable solution. Otherwise, under all circumstances, non-refoulement must be the most majestic, supreme, and paramount institution when we are talking of the global governance of the rights of refugees. So therefore, under all circumstances, this particular right should be protected, because there should not be forced deportation from the country of reception to the country of what we call of origin of refugees. Then how to define international protection? How should we try to capture a basic and the most fundamental understanding of international protection? What are the possible avenues, understandings, concepts, contexts where we should try to locate the idea of international protection in terms of definition, in terms of meaning, in terms of its conceptualization? That
Sir,
yeah, please.
sorry for interruption.
No, not at all, man. Most welcome.
Yeah, sir.
At least I am basically, whenever there is any kind of intervention or any input from the students community, I take it as some kind of a blessing, because you are giving some kind of a respite to my vocal cords. Yes, ma'am.
Uh, so my question is, sir,
Yeah.
like in the refugee law, like
Yeah.
though the human rights treaties guaranteed the right to seek a asylum of the asylum seeker, but it nowhere confirmed the right to be admitted as a refugee. So I think there is a difference between these two, right? Only the right to seek asylum and right to be admitted as a refugee. So while the international treaties confirm the former right, it does not confirm the later right. So my question here is, once a person get displaced from its national territory, till the time it get admitted in the territory of other country, can we say that there is a vacuum situation? There is a gap in the international protection that one should provide it to this person. Can we consider so? Like, is there a vacuum?
Actually, in my subsequent submissions, I was about to what you call because I was going to attend this question in the next week, and that is the week 5th. How to determine and how to grant refugee status. But since you have agitated me at this stage intellectually, it's an intellectual regalvanization on this particular point, and I immensely feel that at least whatever the deliberations are taking place, these deliberations are being rightly taken. It is the most controversial question And Miss Prakriti Malla, there are scholars who came out that it is a golden gap. It's a golden silence. Because if you take into account the mandate of Article 14 of the Universal Declaration of Human Rights, where see the language of the framers of Universal Declaration of Human Rights. You can correct me because Universal Declaration of Human Rights is not before me. But if I correctly recall, Article 14 simply lays down right to seek asylum in another country. This is how Article 14 begins. So right to seek, but it does not mention that state shall also be under obligation to grant asylum. So you have rightly asked this particular question, right to be admitted as refugees. That is your question. Because there are controversies on this particular notion. There are scholars, there are students, and you can also count me as one of the students who advocate that if somebody is seeking asylum, then definitely there is a inherent, it is one of the most important aspect of the intersectionalities of Article 14, that state is under an obligation to grant asylum. Because when there is a credibility of grounds, when there is a credible situation, that situation has already been corroborated, approbated, while cross verifying the circumstances in the abnormal circumstances, hostile circumstances, and all the grounds or one of the grounds which have been adumbrated as persecution grounds in the refugee definition in 1951 convention, then it is the obligation of the host state or the country of reception, or whose doors are being knocked by a particular refugee or group of refugees. It must grant asylum to those or extend some kind of a protection, international protection. Because if we claim ourselves to be a civilized nation state, then it is the fundamental responsibility in the light of purposes and principles of United Nations Charter, where adequate provisions are there, where it has been promised, it has been guaranteed that the human rights of all, fundamental freedoms of all shall be protected. So that is my contention. But there are scholars who are raising objections, who are opposing, who are having some kind of a question. And it's a very, very valid questions, because every question is having certain important justifications. So on the basis of those very justifications, right to be admitted as refugees in country A or country B or XYZ, whatever may be the country, people are questioning that we are not under any kind of an obligation. But I totally oppose this kind of a contention, because there are state obligations, state international obligations, state international human rights obligations, irrespective of the fact, madam, whether a state is a privy or party to these 9 core international human rights treaties or not, or any one of them, it is immaterial. Because under customary international law, under the doctrine of just cogence or the preemptive norms of international law, particularly in the context of human rights, nation states are under an obligation to provide and extend international protection to people fleeing persecution. So that is my contention. Any other additional dimension you intend to share, ma'am?
At this stage, no, sir.
Yeah. So you are having, using the 2 email, connections. I mean, 2 internet connections.
Yes, sir. Because like sometime it got interrupted. That's why, like, so that I couldn't miss your.
Okay. Thank you, ma'am. Thank you. Any other question, my dear friends, or any other, some supplementary observation on your part? Let me go to the chat box first. Yeah, thank you. There is nothing. Yeah, any observation? Where is Mr. Muhammad Imran? Yeah, Mr. Jamshed Sahib. Mr. Vikash, are you there?
Yes, sir.
Yeah, I want to listen your voice. So say something, please.
What should I say? You just ask any question. I will reply.
No, no, it is very, very important. And I am simply, inviting your observations on the question that Miss Prakriti Malla has, asked. Is there a state right? Because when we are, talking of refugee rights, then state is also asserting its rights. So how is there any kind of a possibility to have some kind of a reconciliation between the state rights and refugee rights? What is your observation?
Mm,
Because one of the fundamental principles of our, more than 5,000 old civilization is the concept of Vasudeva Kutumbakam. So in the light of this particular, understanding, how do you perceive the idea of state rights versus refugee rights? Oh, I understand. I I understand. I got. Yeah. Thank you for your message, Mr. Vikash Kumar. I understand your, surrounding environment where you are, where the silence is the precondition. So you please maintain. You are in right now in library, so you can't air your views. So I understand. Anyway, on some other occasion, definitely I would also be inviting your observations on this particular, point, because this is not the first question, and this is not the last, question. In different, lingual orientation, the same question has been asked in other parts of the world. So we would also be, because yesterday also, even the Prime Minister of Austria has also, aired his views on similar, lines. So anyway, we would be attending those observations.
Sir, sir, hello.
Yeah, yeah, hello.
So like when I saw the 1951 convention, sir, you are talking about the international protection, and I have seen a number of right guaranteed as a right for the refugee under 1951 convention as an international protection. So that those rights ranges from civil and political rights to socio-economic cultural right. And what I feel is like until and unless the state admits a particular person in its territory, they may respect some of the civil and political rights as a just causes rule, like right to life. But there are also some rights which is not possible to implement until and unless the person is given a shelter in the territory of that particular state. So
Yeah.
what I believe is like, as I said, there is no any international convention which imposes an obligation upon the state to admit the refugee. So I feel like when we talk the international protection in the context of refugee, yes, there are wide range of rights, but to the person who has not yet admitted in the territory, they can't enjoy all sorts of right that a person is entitled after being a refugee. And I think this is where the vacuum like situation is still existing in the international refugee law.
Thank you very much for your observation, ma'am. Let me supplement your argument. Domestic political ramifications have been creating these kinds of vacuums, which you are alluding to. Because It is a fundamental understanding under international refugee law. It is the basic responsibility under customary international law, basic responsibility of the state. It is again the responsibility, a sacred responsibility under the national constitutions or international constitutional law, comparative constitutional law, or the constitutionalism that has been produced by the International Court of Justice, by the regional courts on human rights, by the national courts on human rights or human rights courts or the constitution courts, and at the same time the highest judicial establishment in a geopolitical entity. It is the responsibility of all that such kind of a vacuums should never be exploited, because this is a question of of humanitarian crisis. It is a question of human rights per se, and therefore such kind of a vacuums, such kind of a artificial vacuums, manufactured vacuums cannot be allowed to exploit or cannot be allowed to deprive the refugees their rights in the country of reception. Because a person who is seeking asylum, a person who is knocking the doors or fleeing persecution and trying to get the protection in the country A and its borders, then it is a violation of some of the most important articles of 1951 convention, like Article 31, 28, and as well as Article 33 subclause 1 of 1951 Refugee Convention. So when we apply the idea of Article 333 subclause 1 of 1951 Convention, we do not find any kind of a vacuum. So it is the man-made what you call vacuums. There are no legal what you call vacuums. Yes, political and administrative interpretations may vary, and they have created a lot of problems for the reception of refugees in different parts of what you call of the world. And particularly the political question has already been answered by adopting the two important global compacts in 2018 in the month of December, which is popularly known as the UN Global Compact on Refugees and Migrants of 2018. So I do not see, personally speaking, as a student of international refugee law, I do not see any kind of a vacuum. Because if at all there happens to be a vacuum, then this should not be what you call allowed to exploit, because no vacuum is allowed under international human rights law, under international refugee law, for the deprivation, for the denial of what you call of human rights, for denial of access to justice, or access to some of the important courts or constitutional guarantees. Otherwise there is no need to have the provisions like Article 21 in the Constitution of India, or Article 31, 32, and 33 in the Constitution of what you call of or Constitution of Bangladesh, or similar what you call right to life provisions in the Constitution of Nepal. So there is no need. Why the word what you call person or citizen? Two words at the same time have been used in the Constitution of Bangladesh, and the word person has been used because it was in the fitness of things and how the idea of what we call of the world community has been contemplated under various national constitutions, be it the US Constitution or Constitution of Australia, Africa, or other nation states beyond South Asia. There was no need at all to have this kind of a construction of the constitutional language. So in the absence of any kind of a refugee law or refugee protection regime, or if a country or a nation state is not privy to 1951 convention, then there are constitutions, there is a concept of the customary international law, there are certain important what we call concept of the global community of citizens, or the global idea of the global citizen that is emerging and getting some kind of a ground. So under these cumulative circumstances, the constitutional circumstances, the customary international law what we call narratives, we cannot deny, we cannot take the plea, or we cannot what we call surreptitiously take the plea of what we call of gaps and vacuums. So it is not going to be tangible argument, a tenable, argument. It is a, ostensible argument. So this cannot be, entertained. Let me go to the chat box. My friend, Mr. Vikash Kumar, has also, contributed. Each country needs to weigh the potential societal contributions of asylum seekers against the cost which these new arrivals impose on citizens already present and working within national, borders. I accept your argument, Mr. Vikash Kumar, but in a very limited fashion, because there has been a tendency, not only in the global south nation states, where we find the global south nation states have been hosting more than 85% of the refugee population, if you take into account the current refugee population at global level. This is an argument which has also been presented. The similar argument I find in various, administrative officials as well as the politicians from the global north nation states. Because similar argument, I should put it like this: when in the wake of 1971 war of liberation, as per the Bangladeshi orientation, I am using their terminology, because the Pakistanis call it the disintegration of Pakistan or partition of Pakistan in 1971, but it was a war of liberation from Bangladesh point of view. So during this particular time, when India has received more than 5 lakh refugees from Bangladesh, then the late Mrs. Indira Gandhi, while addressing the community of nation states, also argued in similar fashion. She was also having the similar argument, and she was of the view that the infrastructure of India, the logistical support which has been as of now been extended to in the reception of people from Bangladesh or Bangladeshi refugees in India, our infrastructure, all kinds of logistical support is tottering under the weight of these arrivals of refugees from Bangladesh. So when we are of the view that the nation states must weigh the potential societal contributions of asylum seekers, yes, we should weigh. And this has been one of the most important, what you call, contributions, if you take into account the contributions of the refugees in United States of America, particularly the European refugees in the wake of the Second World War, who left European nation states and took shelter in United States of America. They have immensely contributed in the nation building in the sense the development of the United States of America, where whether in all walks of life, United States of America has realized that the refugees have become not liability, rather assets for the nation building in United States of America. So it is not a question, it's a very, very subjective question, though the objective elements may also be there, but this should not be the only objective to determine and to extend any kind of a protection to refugees or to new arrivals or receive in the country of what we call of destination, or in the country of reception of any kind of or any class of refugees. Because ultimately refugees, if we forget for a while their acumenship, their skills, their dexterity, their specialized what we call dexterity, then ultimately in the ultimate analysis at the end of the day, they are human beings. So their humanity should be what we call preserved, and it is the responsibility that one humanity should not be at war with other humanity. So that should be the more potential what we call argument. I understand the quota system, because this is something, whatever Mr. Vikash Kumar you have written, it is also axiomatic from the quota system that has been contemplated by the European Union, how the refugees should be accommodated, particularly the Syrian refugees, or the Jordanians, Lebanese, and Iraqi refugees, Afghan refugees in Germany and some of the other important tiny European nation states, because they were contemplating how these refugees should be integrated with that of the local population. special kind of, orientation programs are being, organized in Belgium, in France, in other, European nation states, and they are being what you call, given some kind of a, what you call, initial orientations regarding the way of life in their new, what you call, territories, and even their though their identity has been, preserved, their distinct, what we call, identity has been, respected. They, the European nations are not indulging as what we have been, witnessing in Xinjiang province of, China, where the re-education camps, which are primarily, as per the global reports, they are the detention, what we call, centers, and a new Platonian concept of, communism is being, resorted to by the Chinese, officials in the Xinjiang, province, against the Uyghur Muslims or the Uyghur Muslims who are having a Turkic, what you call, origin. So we have to, comprehensively see and weigh whatever you are, saying that the potential societal contributions of asylum seekers. So they should be, treated as an, asset, and their individual dexterity and qualifications must also be, taken into consideration. So that is what we call, my understanding, though I do not, deny what has been, what we call, you have, presented, because there should not be any kind of a, imposition. Yes, I do believe that the new arrivals impose on citizens already present and working with national, what we call, borders, because some kind of a via media should be, because I see international protection as a temporary, arrangement. When the situation, gets normal in their country of origin, they should be, what we call, voluntarily repatriated, and it may be the, the national determination of refugee status. So whatever the, durable solutions, trajectories available to us, in the light of that very trajectory, we should try to, what we call, encapsulate these, dimensions and concerns. Again, Miss Anupa Riyal is also making a very, very important, what we call, contribution. That is, there is no legal vacuum, or let's say right vacuum. Then can we argue that the right granted to refugees shall be equally extended to asylum seekers? Yes, this is my, belief. The rights which have been, what we call, granted to refugees should equally be available to asylum seekers, because asylum is the first stage. Because if you take into account the rights or range of rights which are available to refugees and asylum seekers, we do not find much difference. Because the people have been initially seek the political asylum, diplomatic asylum, or, asylum sur place, that is popularly known as. So in these kinds of, situations, primarily, whether it is refugees or asylum seekers, they have been fleeing persecution in their country of origin. So that is my, understanding, that there should not be any kind of a difference, because on the basis of, mechanical or technicalities, nobody should be denied of any kind of a, rights in the country of, origin. Vikas Kumarji again making, or, sharing an example of, Tibetan refugees. They are contributing to Indian society in no lesser intensity than other, common Indian, citizens. Yes, I definitely, what we call, share your concerns and share your, views. Tibetans have been, contributing, and they are our, co-religionists, because they have also been, following a religion that originated in India, or they are having a lot of what we call, common ingredients in their way of life. So it does not mean, because when I, see Tibetan refugees, and they have been living in India since 1959, when for the first time, along with, present, Dalai Lama, they came and arrived in India when Pandit Jawaharlal Nehru happens to be the Prime Minister of India, and they have been wholeheartedly, received, and they organized among themselves and contributed a lot and enriched the, Indian culture, or our Indian or composite, what we call, culture. But there has been some kind of a discriminatory practices among the refugees so far, the in the absence of a proper mechanism how to receive and how to grant some kind of a rights to refugees in India. So far the governmental response is concerned, we are having different responses. Sometimes we find, because each and every kind of a response towards a particular community of refugees in India, the response is always dictated by some specialized what we call circumstances or approaches. Suppose we find, take the example of the Tamil refugees in India, Afghan refugees in India, Rohingya refugees in India, and other classes of refugees. So sometimes we also find that the government of India is having a different approach so far the Afghan refugees are concerned. Government of India grants all kinds of rights, all kinds of assistance, whatever is there within the reach of the government of India. Afghan refugees are treated. But when, despite the fact Afghan refugees do not have any kind of a political weight, if you compare these group of refugees with that of the Tamil refugees. Tamil refugees from Sri Lanka, they are also having political implications, and on many occasions, even in the past, they have also influenced even the foreign policy paradigms. So far the foreign policy of India is concerned, particularly when even during the Vajpayee regime also, when there was a voting that was required in the United Nations Human Rights Council, then it was basically the political implications of the coalition governance under Vajpayee regime in India at that point of a time. So the political, the voting was influenced by the persons of the Tamil refugees, because had it been not so, that definitely that would have created a lot of problems for the coalition governance in India. Then another group is also there, that is the Rohingya refugees. Even the Rohingya refugees, they do not have any kind of a political way. So the question of sovereignty and the national security, that is the most important question. But this is my personal opinion. If you take into account even the subclause 2 of Article 33 of the Refugee Convention, though India is not a part and no South Asian nation state is a part except Afghanistan. So even if you take into account, then there happens to be an exceptional clause, and that is an exception to the doctrine of non-refoulement. So majority of the nation states on some occasions have utilized this particular or invoked this particular subclause of Article 33 of 1951 convention, where they were able, because of the national security, because of terror threats, because of some other important considerations, refugees have been denied entry or range of rights. They have been detained, or some penal actions were taken. They have been deported, they have been expelled in violations of international human rights obligations, because of this particular exception that is also the part of Article 33, where the subclause 1 is taking into consideration the primacy of non-refoulement, but the second clause has created lot of problems. So when we are saying that one class of refugees is good and one class of refugees is bad, that is not in the fitness, or that is in violation, at variance with the mandate of our international obligations. Because I am equally concerned about the Hindu refugees from Pakistan in India. They are not getting their due. A range of rights, particularly the Dalit refugees from Pakistan, who came over here with the hope that India is going to be their natural home, but they are not getting the range of rights which has been promised, and the rights which are available to rest of the citizens in this country. They are not getting any kind of a sense of integration because of the behavior of the local communities in Rajasthan, in Jammu region, in other parts of India, where they have been sheltered, and they have chosen. Because if you take into account Rajasthan, there are a lot of what you call blood relations between both the sides of borders. So those who got uprooted because of persecution in Pakistan and migrated to India, and they are Hindu refugees, they are not getting their due. So we must what we call cumulatively, we should have some kind of a holistic approach how we have been treating refugees. So they should be granted all kinds of rights which are available to all of us as the citizens of this uh, citizen of India. So it is very, very important. But the bottom argument, or the moral of the entire what we call deliberation is that the refugees should never be treated as a liability, because the European nation states are not what we call treating them as liability. Rather, they are being what we call you know treated as some kind of an asset, and their services are being, because gainful employment is one of the most important right, and one of the most important chapter. If you take into account entire convention, 1951 UN convention relating to the status of refugees, you will find that these rights, a gainful right to eke out a dignified livelihood, that has also been made available to the refugees. And by exercising this kind of a right, they have also contributed in the nation building so far the host society, and the development in the whole development of the host society is concerned. So now again I am taking you back to another important what we call question that is still we have to answer. And because of this question we have started, and I have invited, and I really feel enriched because of your interactions and inputs and your contributions in the ongoing deliberations. And the question that I would like to place for your consideration: how to define international protection. So there are certain important observations, and how to attend this particular idea of international protection. So far my understanding, my dear friends, is concerned. International protection can be defined as, this is my understanding, you have every right, my dear friends, to differ, to disagree, and to have your own understanding of international protection, because I would like to contextualize this particular idea of international protection in the context of refugee protection. All actions aimed at ensuring the equal access to and enjoyment of the rights of women, men, girls, and boys of concern to UNHCR in accordance with the relevant bodies of law, including international humanitarian, human rights, and refugee law. It includes interventions by states or UNHCR on behalf of asylum seekers and refugees to ensure that their rights, security, and welfare are recognized and safeguarded in accordance with international standards. Or in other words, we can put it like this: international protection should be defined that the protection of human rights available under 9 core international human rights treaties and other ancillary documents of a human rights nature. And it shall be the responsibility of the nation states to grant these protection mechanisms contemplated in these international human rights instruments as a part of their duty discharging their international protections. So whatever may be the idea, because many attempts have been made, but we do not find, fortunately, any kind of a definition of international protection. Protection has been simply meant, as I have already submitted, the different what we call arguments for protection, nature of protection, compartmentalization of protection, intersectionality of protection, hierarchy of what we call of international protection, whatever may be the nature of those very protections. But we should what we call make available all such kind of protections to refugees. But we can further, understand the idea of international protections on the basis of requirements, on the basis of, needs. Suppose the very first need of a refugee, the very first need, very fundamental, what you call, requirement of a refugee is safety, admission to safety. So therefore, refugees who have crossed an international border, crossing of international border, my dear friends, may require that UNHCR or other members of the international community be present at the locations where a refugee could be refused some kind of a, refused some kind of a protection, entry into the country of asylum. So, the officials of a country should be present at such, places. What are those places? Border. And that is why I call that the border justice, when I am using this particular, terminology like, border justice, it means the officials, state officials, or the sovereignty which is represented by those very, law enforcement agencies or the border checkpoints where the, national personnel and the national, border guards are, posted, then they should also be well versed to how to what you call extend border justice. This is my understanding, and I call it the border justice. So we have to what we call extend border justice to refugees. It means locked borders should be, opened. Highest amount of, respect for the dignity of those people who are fleeing, persecution, that should be restored to them at the border. I'm not saying immediately they should be admitted. Yes, the procedure for their entry may be completed within a reasonable, time frame. And on the basis of those, time frames, we can contemplate, though it is not possible to determine the refugee status of a, in a mass migration situation, individual, migration situation, we can, determine at the border. But cumulatively, immediately, a sense of safety kind of, protection should be extended to them. That is a notion of, border justice as I, perceive this particular idea. Again, there is a query. Office of the High Commissioner of Human Rights intervened in the Supreme Court on CAA issue. Don't you think, sir, that this voluntary activism by the body will put a great strain on principle of diplomatic immunity? How would Office of the, Human Rights Commissioner be made to pay cost? Should Honorable Supreme Court decides to impose such, cost, will it not lead to diminution of principle of diplomatic immunity? I have a variant view. If international agencies and international organizations making some kind of a request for impleading before the highest court of the land in any geopolitical entity, and in this case you have raised a Indian situation. Tomorrow some other important international non-governmental organizations or governmental organization of an international character or some subsidiary organizations of the United Nations organizations, they can also come and request for impleading. In such a situations, the views of the government of India may also be sought by the highest judicial establishment in India. Because if somebody is requesting for impleading or going to become a party or privy to a particular litigation or in a matter that remains sub judice or in the ongoing limitation, that our version should also be heard if somebody is making this kind of a application. Then in response to that particular application, the notices should also be issued to the other important stakeholders, because we are living in a globalized world, and it is the responsibility that the globalized world should also be a constitutionalized world. We should not simply contend that there happens to be a violation of the Vienna Convention on Diplomatic Immunities and Privileges. We should not contend that it violates some of the provisions of the Vienna Convention on Law of Treaties of 1969. We should not take the plea that it is against the purposes and principles of the United Nations Charter, because we have to coexist with multilateralism, and the judicial establishment is not an exception to this particular understanding. Exclusively speaking for myself, because in the field of law there are different streams of understandings, and with due respect and due regard, as a citizen of this country, that is India, I am of the view, exclusively speaking for myself, you have every right to disagree with me, Mr. Vikash, that it is the Supreme Court of India who can settle this particular issue. Because there have been instances where the Supreme Court of India has also invoked international conventions, international legal thinking, internationally acclaimed juristic writings in the field of international human rights law, in the field of private international law, in the field of international humanitarian law, and in the field of constitutional law. So it is not a question of diplomatic immunities dilution or diminution or some other forms of impact. If somebody is coming, whether it is some international organizations recognized by the government of India, recognized by United Nations organization, we should entertain them, and we should settle each and everything in the right perspective, because we are today having an international stature. If I specifically speak as an Indian, then India is a nation state which cannot be browbeaten by these kinds of impeding interventions. We have enough jurisprudence, enough wisdom in balancing tensions between human rights as well as state concerns. We can create a reconciliation which is going to be legally acclaimed. So that is my contention. If somebody is coming, that should not be taken otherwise, rather we should give them a befitting jurisprudential understanding. So that is my contention. Any other observation?
Sir,
Yeah.
I have a query in regard to the same question, sir. Like,
Yes,
if you
ma'am.
see the charter of OSCR, it says that the OSCR has a function of facilitating the government, national government, rather than intervening. So, like here, when the OSCR directly approached to the Supreme Court, can't we consider that this violates its role of facilitating? Rather,
No,
it seems.
no, ma'am. I'm sorry to cut you short. I'm extremely, I apologize. You can, further, enrich me. Ma'am, yeah. Ma'am, approaching to Supreme Court of India, I do not see as a violation or a dilution of its, mandate. I see this particular step on the part of human rights organization as a different kind of a very mature kind of what you call step of facilitation, because it has invoked a judicial what you call remedy. It is facilitating further and clarifying its own stand. This should be taken like this, because if somebody has gone to Supreme Court, then the Supreme Court cannot be cannot dismiss something in limine. If I am using in limine means summarily, so summary rejection cannot be there. So it's a basically on the part of human rights, such kind of human rights organizations, yes, there may be some kind of a understanding that it intends to internationalize something which is not likely to be entertained politically by the government of India. Yes, I can understand, but this internationalization of a particular issue should also be given a judicial understanding. Even the Supreme Court of India, there are many options which are available to the Supreme Court of India. Supreme Court of India may also come out with the reasoning, since it belongs to the to international what we call entities, that is the government of India and an international organization, then they should what we call, this is beyond our purview. This could also be one of the options or plea on the part of the Supreme Court of India, or there may be another important a judicial recourse may also be there, that within the Constitution of India, tomorrow the Supreme Court of India may also come out with the reasoning, yes, if Constitution of India and international what we call human rights obligations allow, if they are interpreted combinedly and harmoniously, then this kind of a remedy may be available. So it could be one of the important options. So the invoking judicial remedy or accessing to the judicial mechanism is one of the well established what we call practice. So this is my understanding. I may be wrong. I am amenable to all kinds of corrections. I do not have, this is my judicial understanding, this is my academic understanding. So on the basis of this academic understanding, I am having and holding this kind of a view, but I am subject to all kinds of corrections, because in the field of academia, we cannot use the word finality, because everything is in the field of law, everything is dynamic. So we cannot deny the dynamism. There is every possibility my argument may not sustain in the persons of the cumulative understanding and cumulative appreciation of the circumstances within which this kind of a impleading has been there before the court of law, and that too at the highest level. Any other observation, Vikas sir? Yes, Vikas ji. Regarding the mandate, Mr. Vikas Kumarji is again writing, regarding the mandate gives us two inferences. Firstly, a state needs to ask the OHCHR, and only then an advisory can be tendered. It cannot be on a voluntary basis by the OHCHR as per its own mandate. Secondly, such an advisory can only be provided to the executive wing of the government of a state by virtue of section 3 subclause A of mandate, because advising to a domestic court, even when asked for, with amount to inferences with the domestic jurisdiction and sovereignty. This is also because foreign affairs is executive domain of the executive. Yes, I come. So far, your first argument, Mr. Vikas ji, is concerned, I completely agree with you. Number two, so far your second important argument is concerned, it may also come out as one of the important options from the Supreme Court of India. If it is going to be the part of the brief, of the Attorney General of India or the Solicitor General of India, then it may be one of the arguments that may be deposited, that may be submitted as a government or official averment before the Supreme Court of India, and it may also come out from the spontaneously from the Supreme Court of India, and there is no harm at all. But it has become a fashion of late, what we have been witnessing. That there happens to be a process of judicialization of international relations. There happens to be a judicialization of international political issues. And it has started at judicialization of the domestic political issues within the national territory. Now it has also attained international proportions. Because it has been further necessitated because of certain fundamental changes in the circumstances in all the geopolitical entities. And that has also been further pointed out by the latest report of the Freedom House, if you take into account. Because the fundamental freedoms, particularly democracy, has been weakened. It is further axiomatic what kind of a level of freedom in terms of fundamental rights, in terms of race, religion, caste, creed, political opinion, social origin, and other considerations including gender, children, what kind of freedom and what are the grounds I have enumerated before you. So that has become the criteria to determine the threshold of freedom available in terms of enjoyment, in terms of accessibility to the fundamental freedoms. So it is not a very good report for entire world. Because what we have been witnessing, whether the South Asian jurisdictions are concerned or EU jurisdictions, particularly the countries like Spain, Austria, and other European nation states, and some of the nation states from Africa Union, and Latin American countries, particularly Brazil, Mexico, Venezuela, where the political discourse has attained a different kind of a yardstick, a different kind of a measurement. Any counter argument has become very difficult to be heard. Despite the fact even the constitutionally oriented languages of oppositions are not going to be appreciated. That has become a very, very important bone of contention, and that is very important for a thriving and vibrant democracy. This is my legitimate understanding, my dear friends, that you might have studied one of the most important treatises written by Plato. His idea of republic, the Republic of Plato, or Republic written by Plato, where he is making lot of what he call claims of democratic governance, and how the democracy has converted into some kind of an aristocracy, and how aristocracy ultimately resulted in some kind of an oligarchy. So governance is of vital importance, because history has witnessed people, rulers, democrats who ultimately turn out to be the dictators. And in India, in South Asia, democracy has always been seen as not a one-way traffic. In our, the understanding of, democracy in our part of the world is a, cross-fertilization of constitutional ideas. And speaking strictly for myself, my dear friends, one should be very careful about his, lingual orientation. Language under all circumstances in a democratic political setup must be constitutional and parliamentary. It must conform to the civilized norms of human existence. And therefore, if you take into account all these, circumstances, you will find that the governments should not be criticized for the sake of, criticism. Rather, there should be a fair criticism. Fair criticism in the sense that some corrective measures should be invoked, should be, resorted to by the government. Constructive suggestions should be offered to the government. So therefore, what is important is there has to be a sense of what you call of, accommodation, political accommodation, a sense of reception for the counter arguments. Counter arguments does not mean unconstitutional argument or impragmatic, arguments or unplausible, arguments. Counter arguments must also be equally constitutionally sensitive, what you call, offerings. Even if you take an example from Pakistan, it has got only 37 points. Whatever may be the, organization, even tomorrow the South Asian institutions may also what you call, evaluate the level of democracy in South Asia. We can have our own, institutions of, rankings and ratings. If we do not believe these, Western institutions or American institutions who are ranking our democracy or rating our democratic functioning of the governance institutions. But I believe that even in democracy, my dear friends, strict discipline should be there, and it should be in the interest of, democracy. And sometimes the strict and regimental discipline has been perceived as intolerance of, governmental institutions. But I believe no society can flourish if there is no what you call, discipline, if there is no anusasham. In Sanskrit or in Hindi, we call it. So this is very, very important. Particularly, I am not saying of India alone. Rather, I am making this particular argument for the entire what you call, community of Afro-Asian nation states. Personally, what I see that despite the fact we have been pulverized, plundered, destroyed by the global North nation states, but we always, lacked some kind of a discipline. Discipline in our, social relations, discipline in our, financial management or financial discipline, administrative discipline. These are some of the important, facets of a constitutionalized state. And at the same time, my dear friends, under all circumstances, democracy must ensure diversity of ideas, diversity of human existence, and multiculturalism. That is another important, takes. And therefore, international organizations, if we take into account this entire, background, then it is the responsibility of the international organizations. Whenever the international institutions are, functioning, they should also take into account the constitutional aspirations of a particular geopolitical entity. I understand, and I have already shared with all of you, that nation states and international organizations have always been the part of the subject of international or the subject matter of international law. But of late, particularly in the later half of the 20th century, even individuals have also become the part of of international law, and therefore, where the individual freedoms are threatened, where the community freedoms are threatened, where the civil and political rights, socio-economic and cultural rights are threatened in any geopolitical entity, then they may also be contended before a court of law. It may be of a regional character, it may be of a national what you call forum, judicial forum, it may be an international judicial tribunal. So history is replete, and many states have also what I am coming to your conclusion as well. So we have been what you call espousing the cause of individual freedoms, and when we basically see individual freedoms, I see this as a protective shield that should be extended to refugee community, because we are studying basically and engaging in a very important what we call discipline, and that is how to protect refugees, whether it is going to be surrogate protection, international protection, subsidiary protection, temporary protection, whatever may be the nature of protection, but we have to protect human beings. Refugees are also the human beings, and therefore their concerns. Subsequently, we may decide restrictions and everything, because even under the Constitution of India and rest of the constitutions from South Asia, for properly regulating human freedoms, there are certain important limitations and restrictions, and no constitution in the world is an exception to these restrictions. But what should be the threshold, those restrictions, under what circumstances these freedoms are going to be derogated, and how to invoke the law of derogation in limiting those very fundamental freedoms. So there has to be some kind of a reconciliation, there has to be some kind of a balancing act, how to balance such kind of freedoms. So Mr. Vikash Kumar is of the view, while institutions need to be strengthened, yet at the same time they must be bound and restricted within their express mandate as enshrined in their constitutive documents. A weak institution will defeat the aim of refugee protection, while its activism may delegitimize its cause and thus hampering the human rights protection domain. Yes, I concur with you. This should be the note of caution. I agree with you, Mr. Vikash Kumar. But at the same time, there should be some kind of a clarity when we are, saying express mandate. Is there any kind of a possibility to infer or to have some kind of an inferential consequence of implied mandate as a part of the express mandate? That is another important dimensions, if I prima facie if I understand, but cumulatively I understand, I support your argument. This should be there. Any other observation? Well, thank you very much, my dear friends. It has been a very lively debate, and tomorrow I would definitely conclude what I have started, and that is the idea of international protection. And we are going to decipher this particular idea of international protection on the basis of needs, on the basis of requirements, on the basis of what we call of ground realities. And thereafter we will switch over to another important dimensions, and those dimensions would be exclusively going to address what is the possibility of expanding the grounds of asylum beyond durable solutions. So thank you very much.
Thank you, sir.
You're welcome.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you,
Thank you,
sir.
Sampaji, a lot for your participation. Yeah, thanks a lot, Mr. Muhib Saab, Asif Bhai, Ehtasham Saab, Mr. Sultan, Mahmood Saab, Awal Khan Saab, Ms. Tasneem Bin. Thanks a lot for your participation. See you tomorrow at the same time. Thanks a lot. Bye bye. Take care.